Council Intellectual Property Sikorsky Aircraft. His presentation, as you can see here, is a very important one and is entitled What Every Engineer Needs to Know About Intellectual Property Before Entering the Workplace. This is something very important. Bob serves as the Chief Intellectual Property Attorney for Sikorsky Aircraft, responsible for leading and overseeing intellectual property activities across the company. Bob joined Sikorsky in 2014, serving in other UTC businesses, beginning in 2006 as Assistant IP Counsel for Hamilton Sundstrand Corporation. Bob also serves in the United States Army as lieutenant and captain for over a decade. Bob holds a Bachelor of Science from United States Military Academy, Master of Arts in Military History from University of Calgary, and a law degree from Syracuse University. Without further ado, please join me in welcoming Mr. Selman.
Thank you very much. I appreciate that warm welcome. A couple of ground rules at the beginning. First of all, any opinions expressed here are entirely my own. Any mistakes you see on the slides, entirely my own. They don't belong to UTC or Sikorsky. I'm not providing any legal advice, so this is purely a matter of describing what the law says. I'm not giving legal advice to anybody. How's that? Work okay? Can you hear me in the back? Great. And I would ask you to keep your questions until the end. I'll give you an opportunity at the end to ask questions. I sometimes find that's the best part of the presentation. I get to find out what's actually on your minds. I won't go into any great detail on the background. This is the agenda that we're going to follow. Dr. Ravi covered my experience within UTC and otherwise in my career. I'm not going to go over that again. And I'll just get right at the heart of it. So what is intellectual property? We're all familiar with forms of property that we can touch, right? We've got a computer, or we've got a car, or we've got maybe a house, or we own land or something like that. That's real property or physical property that we can actually handle. Intellectual property is stuff that we create in our minds and you generally can't hold. So there's a difference between the intellectual property rights that are associated, say, with a painting and the actual physical manifestation of the painting itself. Intellectual property attorneys kind of group them into these four different categories: patents, trade secrets, trademarks, copyright. Sometimes you see slightly different categorizations. Maybe you'll see some other minor forms of intellectual property that are addressed. These are really the major ones that most people deal with, and that certainly you're going to be confronted with in your job as an engineer. Each of these forms is distinct. You may find in some cases that there's a little bit of an overlap. Two different kinds of intellectual property may protect different aspects of a particular invention or concept. The one I'm going to spend the most time on is patents. Patents are the ones that most of my team at Sikorsky spend the most of their time on, the majority of their time on. They're the ones that I think most people tend to think of when you consider intellectual property assets that are held by a lot of companies. So what is a patent? Most people would describe a patent as a 20-year monopoly that an inventor gets in exchange for disclosing their invention, and in exchange for disclosing the best way to carry out that invention. Monopoly may not be the best way of phrasing it. I'll describe in a little bit more detail later on why I think you're really better off calling it an exclusive exclusionary right, but we'll get to that later. Patents are provided for in the United States Constitution. Article 1, Section 8 gives Congress the power to give protection for a limited period of time to inventors. So even in 1788, people in the United States were thinking about how to protect the products of industry and what we could do to ensure that companies were going to innovate and would have that innovation protected. The term is 20 years, as it says on the slide. That's consistent pretty much throughout most of the world. The United States is actually kind of a latecomer to that. If you run into people wherever you go to work that were involved in patenting, say 15 years ago or so, patents had a different term in the United States. But a couple decades ago, we decided we needed to get on board with the rest of the world One of the things that we did, we signed on to a treaty that required us to standardize our patent term at 20 years. That sort of a treaty is also the kind of thing that allows inventors in the United States to get protection for their inventions elsewhere in the world. If you invent something here in the United States and get a patent on it, you're not limited just to getting a patent here. You can get it in China, you can get it in Germany, you can get it in Canada, and you can extend the protection elsewhere. So what is it that a patent would cover? A patent should cover something that's new. It can't be something that's been done before. It doesn't make any sense for me to go to the patent office today and submit a patent application on Eli Whitney's cotton gin. It's been done, it's not new, can't get a patent on it. It also, according to patent law, has to be something that shouldn't be obvious. I guess another way of saying it shouldn't be obvious to people that are working in the industry. A good example of that is if you know how to make something out of, say, stainless steel, it might, in most cases, be obvious to make it out of some kind of composite. So things like that may not by themselves be patentable. The other requirement is that it has to be something useful. That's not a very high bar. If you look through the patent office records in the last couple of decades, you'll find that the patent office has determined that it was useful to grant a patent on a method of exercising a cat using a laser pointer. I don't know about you, but I'm not so sure that's necessarily useful, but that apparently met the standard for that patent examiner. The categories of things that a patent can cover are the ones that are listed here on the chart. I'll just briefly explain some of those in a little bit more detail. So a process, some way of converting some element of material into some other form. Making a machine. We can think of things like a computer as a machine, maybe a 5-axis machine to make other parts. Gears, those are all sorts of things that would be covered as a machine. A manufacturer, pretty much anything that is developed by human effort or work, anything that you can do by your human actions. Compositions of matter, think about things like drugs, alloys, materials. A couple of decades ago, somebody came up with Kevlar. There's an example of something that's a material would fall in that compositions of matter. And the patent law also provides for improvements to all of these things. So it's not as if you have to come up with a very basic thing. Even if you improve something that already exists, you may be able to get a patent on it. There are a couple of things that are not included in here. Some things that the law by court decision has ruled out and said you can't get. So you can't get a patent on products of nature. So if you discover a new species of animal, you discover a new species of plant growing in your backyard, those are products of nature. You're not going to be able to get a patent on something like that. Generally, a lot of algorithms may be very, very difficult. Certainly mathematical formulas. It's not like you could take the formula for force and say, hey, I want to go get a patent on that. Another example of something that you wouldn't be able to get, so for not a product of nature, but laws of nature, right? So the first person to discover gravity, Newton wouldn't be able to go to the patent office and say, I want to get a patent on the law of gravity. Laws of nature like that are not something you're going to be able to get protection on. Now, there's a little bit of a nuance here, and I'll give you an example of something that goes back to the 1980s. It is possible to take a living organism and make some modifications, genetic engineering, if you will, and get a patent on that. So, early 80s, someone developed a genetically modified bacterium to consume petrochemicals. It was thought to be useful as a way of cleaning up oil spills. Initially, the patent office said, no, we're not going to give you a patent on that. It's a living organism. It's a product of nature. Went all the way up to the United States Supreme Court. The Supreme Court said, no, not really. That's something that we would consider a manufacture. It's something that somebody took that original organism, that original bacterium, made some genetic modifications and turned it into something else. The patent can go on that. So they were able to get a patent. There are other examples of things you hear about companies like Monsanto coming up with genetically modified seeds. Those in many cases are ones because of the genetic modification. Even though it's something living, even though it's something you think of as being natural, they can get a patent on that sort of thing. As a general rule, if you hear somebody say, hey, that's a pretty good idea, there's a reasonably good chance that's something that could be patented. I want to emphasize that it's not something that has to be a real eureka moment. It's not like it's something that has to be earth-shattering or groundbreaking. Lots of very, very minor improvements are things that are patentable and the patent office will allow. Some examples that I'm aware of just within my work at UTC. People have gotten patents on gears where there is a very unique shape to the teeth on the gear. Everybody's known about gears for centuries. Well, the specific shape of those teeth was enough. The patent office said, that's new, that's new. We're going to allow you to get a patent on something like that. So I described that a patent is an exclusionary right. So for 20 years, the patent owner has the right to exclude other people from making that invention. They have the right to exclude other people from using the invention, selling the invention, offering it for sale, or importing it. A patent, though, is something that is a geographic right. So I described United States patents. We're subject to treaty. You can also get patents in other countries. Any one country's patent, though, is only enforceable in that country. So if you get a United States patent, you can stop people from doing these things in the United States. You wouldn't be able to go to Canada or go to Mexico or go to Europe and assert your US patent and say, you've got to stop making my patented product here. You can, however, stop companies that are in those other countries, manufacturing them there, and then trying to import them to the United States. You can't stop that using your US patent. The patent, though, is defined by the claims. And so if you think about other forms of tangible property, it's very, very simple to know what is your car, what is your computer, what is your cell phone. Those kinds of property, we know what it is. A good analogy here is perhaps real property. Several years ago when I first bought a house, I had a chance to look at the chain of title for my house. The original grant was something where it described going from this iron post to this intersection of a river and some path to this tree or something like that. Those are what we call in the law meets and bounds. So they describe the boundary of that piece of property. In the case of patent law, you don't have that same sort of description. You've got other text, like what I've shown up here on the slide. This is an example from one of our patents. And you can see here, if you read through it, it calls for a certain different components that are going to be around a fairing on a helicopter. You have to have a lower rotor, an upper rotor. You got to have a shaft. It defines a center, and the fairing has to go around that center, and then you got to have a planetary gear system to control the position of the fairing. So somebody that has a device that fits within this description was somebody that would be infringing this particular patent. As I said, a patent is something that allows you to exclude other people. It doesn't necessarily give you the right to do what's in your patent. There's a couple of examples here that I think kind of make that clear. It's possible, as a matter of a new process, to get a patent on a different way of making crystal meth. Well, I think the government probably has a problem with people just going out and making crystal meth in the garage. And so even though you might be able to get a patent on that from the patent office, you're not going to be able to use your patent because doing so would be violating the law. Another example would be that you might be able to get a patent on something. Perhaps it's an improvement. That's the best example. You may not be able to practice your improvement because somebody else has a patent on the underlying product. Here's a pretty concrete example that I think will illustrate that. So imagine that you're company X and you've developed the first folding knife. You go out and you get a patent on it. You've got patent protection on that folding knife. Somebody else is at company Y. I'm at company Y, and I think, wow, what a great idea. Are there other things that I can do with this? What if I put a file on it? What if I put a pair of scissors on it? What if I put a whole bunch of tools on there and all have them fold? Wouldn't that be a great idea? I can go to the patent office and get a patent on my device as well. The problem that I'm going to run into is that when I want to go sell this, it's still a foldable knife. When I want to make this or offer it to somebody in the United States, use it, it's going to be a foldable knife, and I'm going to fall within the bounds of Company X's patent. So that's a problem for me. In the case of Company X, they've got kind of a similar problem. They may see the way the market really is going. They may know that people really want to get a multi-purpose foldable knife. They can't make it because I've got a patent. There's a little bit of a stigma there, but it does illustrate the point that even though I'm able to get a patent on my multi-purpose foldable knife, I still may not be able to make and sell that knife because it's blocked by Company X's patent. So when that happens, what does a company do? And this is something that we work with Sikorsky, other businesses within UTC deal with as well. Other people have patents that might cover the products that we want to try and make and sell. So what is it that a company that has to do if they want to be able to sell their product? Well, the first thing I try and do is work with the engineers within our organization to see if there's another way to design the product. We'd really like to be able to design around that other company's patent if we can. If you think about the real property example again, and it's always, it's rather than trying to fight your way through somebody else's property or plot of land that they own, it might just be simpler to walk around it. And that's really what you try and do when you think about designing around. You want to get your own engineers to apply their creativity to come up with a new and creative solution that doesn't fall within the scope of the original company's patent. That's designing around. It requires a fair amount of collaboration between the engineering organization and the legal department to make sure that you really do avoid the patent and that you get a really good engineering solution that's actually going to work for your customer. Another way, in some cases, that might be practical is to kind of roll the technology back. So if somebody has a patent that is relatively new, well, maybe you can really still use the older design. You can go back to an old patent, one that's expired. Maybe that technology could still be useful for the purpose that you're working on. Maybe that would be a way to do it without infringing somebody else's intellectual property rights. If neither of those solutions work, then you get into some things that are a little bit more complicated and a little bit more difficult. You can always go to the patent owner and try and get a license from them. They own the patent. They're entitled to give you permission to use it if they want. In most cases, they're probably going to say, I want you to pay me some money. They're probably going to require a lot of money, maybe more than you want to pay to be able to use their patent. Another possibility would be a cross license. So if you think about that knife example for a moment, okay, I've got my patent on the multi-purpose foldable knife. You've got the patent on the foldable knife. Maybe we enter a cross-license agreement, and I let you make the multi-purpose features of my patent, and you let me make the foldable knife features of your patent, and we can both go out there and sell our product in the marketplace, and we can then together stop other people from making either one of our products. So in exchange for giving up a little bit to somebody else, we can still protect our position in the market. That's where a cross-license could be useful. Really the last option, if you're confronted with a situation where somebody else's patent is blocking what you want to do, is to try and invalidate the patent. There's a presumption that every time the patent office issues a patent that it's going to be valid. The courts look at it that way. They assume that from the starting point it's going to be okay. But if you bring enough evidence forward, you can convince the judge that the patent examiner really wouldn't have issued the patent if they had known a bunch more information. And so that's really what's involved if you're talking about invalidating a patent. You've got to find evidence that if the patent examiner had it in their hands when they were looking at that patent, they would not have granted the patent to that person. Once you get all that evidence, you can go to court, you can present that to the judge, present that to a jury in some cases, and say, look, this is why the patent examiner never should have granted it. You should declare that patent invalid. You should let me go out and make my product. It takes a lot of time, it takes a lot of engineering and legal effort, and could take a lot of money to make sure that it gets done well. So, you've come up with a new invention. When should you file a patent application? The best answer is as soon as possible. You really want to do it sooner rather than later. In part, that's because there's been a change in United States law within the last 2 or 3 years. Again, the United States, in lots of respects, patent law has tended to be out of step with the rest of the world. We got our patent term aligned with everybody back in the 90s, but we were the only country in the world that had what was called a first to invent set of patent laws. That changed. Now the United States is like the rest of the world, the first inventor to file. So if 2 people are independently working on the same technology and both get the same invention in their head at around the same time, under the rules in the United States, the first one to get their patent application on file in the patent office is going to be the one that will be entitled to the patent for that invention. And the other person, even though they truly invented it, even though they independently came up with the same idea, is going to be blocked from getting the patent. So it really does become important to get to the patent office as soon as you can. You don't want to wait a long time, especially if you may be in a race race with somebody else who's working on the same kind of technology. And that comes up in lots of industries. Okay, so I'm in the helicopter industry. Our engineers are working on some of the same kinds of problems. We want to solve some of the same problems that all of our competitors are. It just wouldn't be unreasonable for inventors at different companies to come up with similar ideas and get them to the patent office, and both want to get patent protection on it. So I always encourage the engineers that work for me that they get those invention disclosures submitted as soon as possible. Even if you're not in a race with somebody, there's still some very, very good reasons to get that patent application on file as soon as possible. You certainly want to get it on file before you start making a public disclosure of the invention, before you offer it for sale, before you show it to anybody, before you put it in any kind of a trade show or tell anybody outside of your company about it. All of those are things that outside the United States, if you make that kind of a public disclosure, you've effectively eliminated your ability to get a patent. Even in the United States, if you do something like that before you file your patent application, it starts a 1-year clock ticking. You've got to get your patent application on file within that 1 year, otherwise you're out of luck, and the rest of the world can use whatever you've demonstrated to the public. So let me describe briefly a little bit what the patent process involves. I guess a good starting point would be, who's an inventor? You got to have an inventor for there to be a patent. Under U.S. patent law, an inventor is the only person that's entitled to submit an application for a patent for an invention. So who is an inventor? Well, it's got to be somebody that's got a substantial contribution to the conception or reduction of practice of the invention. It can't be somebody who's simply carrying out some other instructions or performing the sort of activities that are conventional or standard in that field before the patent was identified. And that's measured with respect to at least one claim in the issuing patent. So I described that the claims in the patent define what it protects. The patent might have 1, 10, maybe even 100 claims. If you can show that you made a substantial contribution to the conception of any one claim in that patent, you'd be considered an inventor on that patent. Typically, somebody would not be an inventor if their only contribution is identifying what the problem is to be solved. I'm sure each of us here could identify probably half a dozen problems that need to be solved before you can get a human being on Mars, right? Well, that doesn't mean that when somebody ultimately solves those challenges that we should be considered inventors for whatever that invention is. So just identifying the problem is not enough. Just suggesting the end result is not enough. Managers often give a goal or a target. We're going to make a helicopter that flies X knots. Well, that's suggesting the goal, but it's not telling the engineers, or it's not describing to the engineers how they're going to actually go about doing that. And then, as I said, the standard activities of drafting or assembly or manufacturing, those are things that aren't part of the invention. If somebody is given some instructions and said, here, go draw this, or go make this in the lab, that's probably not enough to make them an inventor. It's possible that if they add something else to it, if they say, hey, you missed this part, if we change the shape of this piece, it's going to be even better, that could make them an inventor. But that's going beyond the skill that would be conventional in the art. And then finally, managing the people that are working on the inventive process. That's not enough either. And this is something that often trips people up in companies. An inventor says to the patent attorney, oh, we got to include my boss as an inventor on this. You got to include my boss. I don't want to get on his bad side. Well, if the boss wasn't involved, if he didn't have a substantial contribution to the conception of the invention, including the boss, could make that patent invalid down the road. So you don't want to do it. By the same token, if you get somebody who says, oh, you know what, I don't want any of the credit, just leave my name off. The rest of the people on the team, I want them to get all the credit, causes the same kind of problem, right? So you want to make sure that you identify correctly who all the inventors are by this kind of a standard, and that they get included in the patent application when it's filed. So what does the inventor do to start the invention disclosure, start the patent application process? Typically, after they create the invention, if they conceive it in their head, they're going to submit an invention disclosure. Certainly that's the way it works at Sikorsky, and I think most other companies that get that number of inventions probably would do the same sort of thing. The invention disclosure should be the inventor's description of the invention. So it's certainly got to include in text and in drawings what the invention is, but it's often very, very helpful to include other things, right? So you want to know what the problem was that the inventor was trying to solve. What are some of the other things that people have tried to solve that particular problem? What were people doing in this field before the inventor came up with the invention? And then describe maybe a couple of the benefits, why this solution is better than any of the other ones that are out there. It's important to provide that kind of information because it's probably in most cases going to go to somebody who's got to evaluate it to decide whether to file a patent application or not. In companies like mine, we have a committee of technical, legal, and business experts who consider all the invention disclosures. Well, they need to have something that they can work with. We don't typically bring the inventors in for an oral interview. They've got to be able to reduce their invention to a description on a couple pieces of paper or a PowerPoint slide so we can consider it. We think about lots of different things when we're deciding whether we're going to file a patent application on an invention. We think about what's the cost of implementing that invention. Is it something that is going to be pretty simple to put into our product? Are we going to have to build an entirely new factory to do it? Well, if we have to build an entirely new factory, maybe we're not going to pursue a patent on it. Maybe we just think it's a great idea, but we're not going to do anything with it. Is it really practical? What's the scope of the invention? Is it something that addresses a problem that solely occurs on our products? Or is it something that we think really would block some of our competitors and give us an advantage, give us a way of going out to our customers and saying, look, we've got this, the competition doesn't. And in some cases, companies also consider whether there's licensing potential. Even a company like ours, we're certainly interested in inventions that relate to helicopters and other vertical lift machines that we design and build and sell. But sometimes some of those inventions may have applicability elsewhere. And so we might even be interested in, and we might pursue a patent that's got some marketing potential because we know, licensing potential because we know we'll be able to go to other industries and get a good stream of revenue for people that might want to use that invention. Once the committee or the approver has said, yes, this is what we're going to be, we're willing to proceed with a patent application on it, it's going to go to somebody to prepare the actual patent application. They're going to take that informal disclosure from the inventor, and they're going to turn it into something that's acceptable to the patent office. The patent office has a number of rules that are set out in statutes that Congress has passed, and a bunch of regulations as well that the patent office has promulgated. But in basis, they really require that you have a written description of what the invention is. It has to be a written description that enables the invention. So it's got to provide enough description about the invention that somebody who's got ordinary skill in that field, not the inventor, but somebody else who has ordinary skill in the field can pick up that patent application, read through it, and understand how to carry out that invention. What that means is you can't leave out a really critical step just because you want to make sure that nobody else can do it. If you leave that critical step out and you really haven't described entirely how to carry out that invention, the patent office is going to say nope, no patent on it. Or ultimately somebody might be able to get it ruled to be an invalid patent down the road. The other thing that the inventor has to do is describe the best way that they're aware of to do it. Again, you can't sandbag everybody and say, well, there's 3 or 4 different ways. This one is really, really awful, but I'll go ahead and describe that one. That way nobody will try and follow my patent. I can still get the protection, but I haven't told everybody the best way. Again, you can't do it that way. You got to describe what the best way of doing it is. An ancillary piece of the patent application is that an inventor has a duty under the patent law to provide all material that they think may be relevant to patentability of the invention. So if you go back to that foldable knife example that I described, I've got my new invention for this multi-purpose foldable knife. I know about your patent on the basic folding knife. When I submit my patent application for my multi-purpose foldable knife, I've got an obligation to tell the patent examiner, you know, there is somebody out there that has a patent on a foldable knife. I think mine's better than that, but you may want to take a look at it, and you should look at it and make sure yourself that my invention really is patently distinct from the disclosure there. As a patent applicant, that's really a good course of action because it only makes your patent stronger, so it's a good idea to do that. The other thing that the patent attorney or the patent agent who's preparing the patent application will often ask the inventor to provide is what we call a declaration. A declaration is something that has to be submitted to the patent office that effectively is the patent applicant's sworn statement that, yes, I really am the inventor of this patent, this invention. And then finally, the company that you work for will very likely require you to submit an assignment. An assignment is what changes the ownership of the patent from you, the inventor, to your employer as the one who probably owns it. We'll get to that in a later slide. After the patent application is filed, that's when the time really starts to get lengthy. What happens to it? Well, the patent application goes into the U.S. Patent Office. The Patent Office does a very preliminary screen to make sure that all the fees were paid, that all the documents that are supposed to be there are there. If there's supposed to be a declaration, it's there. If there's supposed to be any other papers that are with it, they make sure that all that stuff is there. But they don't really get into a substantive examination of what is in the patent application, what it is that the inventor is trying to protect. They assign it to a technology unit in the Patent Office. You wouldn't want somebody who's a chemist, for example, evaluating electronics inventions. And so the Patent Office breaks their examiner groups down into technology areas. So it gets sent to the relevant technology area, and then it gets assigned to a patent examiner. So the patent examiner gets it, and in most cases probably will not pick it up to do any substantive examination for 2 or maybe 3 years, possibly even longer in some technology units, because there's so many patent applications that are waiting for examination. When the patent examiner does pick it up, what they do is they look at the prior art. They've got search tools, they can look in databases, find out who's got patents in similar fields, who's published trade articles in similar fields, and they can compare the invention that the inventor has submitted to what's been described in the prior art. If the patent examiner does not think that the inventor should get a patent on their invention, the patent examiner will send a notice back to the applicant and say, I disagree, you shouldn't get a patent on here. You've got a limited amount of time, 3 months, 4 months, 6 months, to provide a response to me and tell me why you think I'm wrong. Or maybe change your claims a little bit so that your claims really are different from what's in the prior art. That usually happens at most 2 times for a patent application. At the end of the second round of changes or arguments like that, either the applicant has convinced the patent examiner that yes, they really should get a patent, or the applicant is convinced that the patent examiner is not going to change their mind and has to decide whether they can appeal the decision over the examiner's head or just give up on the patent application entirely. But the process, like I said, can be lengthy. From filing a patent application in the United States to actually getting it issued as a patent can take about 3.5, 4 years, maybe longer, depending on some technology units. So that ends the section on patents. I'll entertain some questions later on when I get done. I'm going to go through some of the other types of intellectual property as we go through here. Trade secret is another category that's very important to a company like mine. And what you'll find in some cases is that many of the same inventions that we protect by patent could instead be protected by trade secret. WD-40 is an example. In the 50s, they came up with this new formula to displace water. They could have filed a patent application on it. The downside would have been that they would have only had 20 years of protection. In that case, a shorter period because it was under the old law. But they would have had a limited period of protection under that patent. By keeping it secret, they still have protection on that formula today. Trade secret protection is something that can last for as long as the owner of the trade secret takes reasonable measures to keep that information for public disclosure. Coca-Cola is another example. The formula for Coke has been around for over 100 years. It's still a trade secret. If you're reading in the news a couple of years ago, some people were trying to steal it or sell it to, trying to sell it to Pepsi, and actually got caught and were brought up on charges. Still a secret. You keep the formula in a safe someplace in Atlanta, and a limited number of people have access to it. The fact that they've been able to keep it secret for that long is the reason that Coke tastes different than Pepsi, and they're still able to maintain a trade secret protection for that. The very distinct difference, though, from patent is that this is not registered with any government agency. A trade secret is not something that you have to go to the government and say, here's my application for trade secret protection. You simply document it yourself that I'm going to maintain this as a trade secret, and you start employing those sorts of protective measures that are reasonable to keep it secret. Among those are putting a notice on whatever documents describe the trade secret so that your employees, your suppliers, other people that are working with the information recognize that this is a trade secret. This is something that they've got to protect, that they can't just leave laying out on a desk, leave on in a hotel lobby, allow somebody to publish it in a trade journal or a magazine or anything like that. Another thing that often comes up in companies, you want to control access, right? So I got a badge and I've got to swipe before I can get into my building where there's trade secrets. I got to swipe it again before I can go into certain places where there are even more trade secrets. So controlling the access is another thing that companies do as a reasonable measure to try and keep that information secret, keep it away from the public. Most employees, and again, this is covered on a later slide, but most employees of companies sign agreements that require them to keep that information confidential. Sometimes it does come up, though, that a company that has a trade secret needs to share that information with somebody else. Maybe it's with a supplier, maybe it's with a customer, maybe it's with a partner who's got to do provide some components to get interface with it. When that happens, you've got to set up some sort of a confidentiality or a non-disclosure agreement that establishes the ground rules that both of those parties are going to apply as they go forward to make sure the information really does stay secret. Trademarks. Trademark is anything that, any name, symbol, or device is used to identify and distinguish the source of goods or services. So if I were to ask you, what does, if I describe a symbol that's an apple with a bite taken out of it, any guesses? Apple computer, right? If you're building a house and you're putting insulation in the walls, pink insulation, anybody know?
Pink Panther.
So you remember the Pink Panther, right? It's Owens Corning, right? So Owens Corning has a patent, or I'm sorry, a trademark for pink insulation. Trademarks are typically associated with goods like that. So it's not like Owens Corning can stop anybody from making anything that's pink. They can only stop somebody from making pink insulation. Apple can't stop your farm stand from selling apples, but they can stop somebody else from making computers with an Apple logo or calling them Apple computers. As a general rule, most trademark owners make a point of trying to have their trademarks referred to as adjectives, not nouns. You would want to call it an S-92 helicopter or a Sikorsky helicopter. The problem if you don't do that is that you run into something that trademark attorneys call genericide. And I won't get you into the inside baseball of why it's called that, but the best example that I can think of is an escalator. 80 or 90 years ago, escalator was a trademark of the Otis Elevator Company. And it was an escalator moving staircase. Well, it became so well known, everybody stopped referring to it as a moving staircase. They called it just an escalator. And when that happens long enough, and people start using that trademark as a noun instead of an adjective, pretty much everybody in the industry assumes that they can use it, and Otis ultimately lost their trademark rights in the word escalator. Now everybody that makes moving staircases can call them escalators, not just Otis. As I described, trademarks are often associated specifically with particular types of goods. So that does mean that trademarks, you may see different companies in different industries using what seems to be the same trademark. United Airlines, United Van Lines. They can both use United as a trademark because when you're going to move, you don't typically think, well, I got to go to United Airlines to get a moving truck. You're going to fly away for a trip. You don't typically think you got to go to United Van Lines to get an airline ticket. That's one example. Another example where coexisting like that didn't work out ultimately was Apple Corp, the company that the Beatles formed to hold their music catalog, and Apple Computing. Those two companies were able to coexist for a long time with an Apple trademark that they both used in some form. But once Apple Computers decided to get into iTunes and selling music, there was a conflict. And so they had to work out an arrangement under which Apple Computer could continue to do that. So what can a trademark owner do? A trademark owner can stop other people from using their trademark in a way that creates confusion or deceives people. So, good example, if I'm the Rolex company, I'm going to go out on the streets of Manhattan and find all those people that are trying to sell those Rolexes that rust as soon as you let them get wet. And they're only charging $50 for what ought to be maybe a $5,000 watch. Rolex has a trademark in watches. Somebody else is out there claiming to sell a watch that has a Rolex trademark on it, they're deceiving people. Rolex has the right to go and stop those people from doing that. In some cases, if you've got what's called a famous mark, you may even be able to go beyond the goods that are associated with your mark. So in the case of Starbucks, yes, their trademark is for coffee, their trademark is for restaurant services, for coffee shop services, but there have been a number of examples where people have tried to make plays on the Starbucks name or the Starbucks logo, even for other goods, and Starbucks is able to stop them because that's what we call a dilution of their trademark. So even those non-coffee uses are enough to weaken the public's image of what Starbucks means, and those Starbucks trademarks as an indicator of that company being the source of the goods. Because of that dilution, Starbucks is still able to go out and stop those other companies. And then the last piece of intellectual property we'll describe is copyrights. So copyrights protect works of authorship, generally. And when I say works of authorship, I'm meaning not just written works. It could be a sculpture, it could be a computer program, it could be a play, it could be a movie. Lots of things like that. Typically, it's creative expression. As soon as it's fixed in tangible form, you have a copyright in something like that. In the United States, the term of a copyright for an individual is 70 years after their death. In my case, the stuff that I do for Sikorsky, the stuff where Sikorsky owns the copyright, in that case, those works are protected for 95 years from whenever we decide to publish them, or 120 years from when they were created, whichever one comes out first. If you're interested in any of the history of this, and if you were to look back in US copyright law, you'll find that the original term for copyright was only 28 years. So in the last 200 and some years, that's successively been lengthened, largely because large companies now have a much bigger interest in copyright, and they really want to make sure that those rights continue for their company as long as possible. So what is it that a copyright owner can do? A copyright owner has the exclusive rights of making reproductions of the work, preparing derivative works, distributing it, or performing it. So because the copyright owner has the exclusive right, that means that they can stop other people from doing that. That's why typically when you go to a photocopy machine, or in many cases when you go to a photocopy machine, you see it might be a sign there that says, making reproductions of somebody else's copyrighted work is probably a violation of federal law. You shouldn't do that. Whoever owns the book that you want to make a photocopy of, or the magazine that you want to make a photocopy of, has the exclusive right to reproduce it. Derivative works are follow-on contributions, right? So think about a sequel to a book, sequel to a movie, a prequel to a movie. Those are things that would be considered derivative works. So Star Wars came out in the late 70s, introduced a number of characters. Well, all of the other Star Wars movies that are associated with that are all derivative works of that first one that came out in the late 70s. How do you protect a copyright? Well, in our case, we've put a marking on documents that we want to protect by copyright. That's not something that is required by law. It's not required to have a marking on there to get copyright protection, but it really serves a useful purpose. Everybody that picks up that document that has that marking on it, picks up the book, whatever it might be, sees that notice and says, oh, wow, somebody else has a copyright in this. Maybe I should explore what my rights are. Can I really do what I want to do with this? I will emphasize that copyright exists as soon as the work is put in tangible form. So a copyright owner doesn't have to do anything. You don't have to go and register anything with the Copyright Office. You can. There's some additional rights that go with that. And certainly if you're going to go take somebody to court, you're probably going to have to go get your copyright registered. But it's not required to have a copyright in whatever you create. So at this point, I want to talk about why does all of this matter? Why is it important for you as future engineers to know what intellectual property is? Well, for one, it's one of the things that your company is going to want to use to establish its place in the market. By developing your IP, you force your competitors to develop their own. You come up with a creative solution, get intellectual property protection for it, you force your competitors to be just as creative and come up with another one. They can't use your solution. makes it harder for them, and it probably makes it better for the consumer because there's multiple solutions out there to pick from. At the same time, it helps ensure a fair return on the investment. When you're out there designing a new product, your company is devoting a lot of resources, your time, the money they're paying you, the lab resources, to be able to come up with this new product. One of the ways to ensure that they get a payoff, they get a return on it, is to have that kind of protection so that the competitors can't practice it. Customers are going to come to you to buy your product and help the company's overall revenues. And then as well, I mentioned the possibility of licensing. It certainly is a lucrative form of revenue for a number of companies to be able to license their IP out to other industries and be able to get money that way. If the positive aspects aren't enough, there's negative aspects as well, right? So we talked about what it means to infringe somebody else's patent and what you try and do to stop the infringement or to avoid it. If you are found to infringe, the damages can be pretty significant. You can see here, just over $2 billion for Pfizer in a drug case, almost $1 billion for Apple in a cell phone case, $1.5 billion for Carnegie Mellon for hard drives and data storage technology. So the amount of damages or the size of settlements has really grown, and it's really significant. So it's certainly a factor for companies. I certainly want to make sure that at Sikorsky, we're not designing our products in a way that we're going to infringe somebody else's patents, because I don't want to subject my company to those kinds of damages. It's also not something that's new, right? So you go back to 1850, Samuel Colt, very litigious in enforcing his patents. I don't know what that would equate to in 2015 dollars, but $15,000 back in 1852 was, I'm sure, a pretty sizable amount of money. So here are a couple things that are probably more relevant to each. I'm sorry, one more thing here on trade secrets. There is also a criminal aspect to this. Misappropriating somebody else's trade secrets not only exposes a company to financial penalties, but it could expose the misappropriator to criminal penalties. This is an engineer who, someplace on the West Coast, is gathering information from his employer with the intent to go sell it to somebody else. He didn't even actually get to the point of showing anybody or selling it. That alone was enough to get him 3 months in jail, 3 months of supervised release, a couple hundred hours of community service, $75,000 of restitution, and not to mention a criminal conviction on his record for the rest of his life. He's not going to be employable as an engineer probably any place at that point. And again, I'll emphasize, he didn't actually provide those protected documents to anybody. He had just gathered them with the intent to do it, and the court said that was enough for criminal punishment. So now I'm going to get something that's probably a little bit more relevant to each of you. Employee IP agreements. This is one of the first IP things you're likely to see when you take a job as an engineer. You're going to show up on the first day and somebody from HR is going to present you with a piece of paper that you're going to have to review and sign. And again, I can't give you advice, but I can describe what those documents typically include. The basic thing that is in most of those documents is something that gives your employer ownership of inventions that you create. Depends on the company, but some of them will base it on whether it was created on company time. Some of them whether it relates to what the company's current business is or what the company thinks it might do in the future. In other cases, it's whether it's using company resources. Maybe it's all three, maybe it's a combination of them. Those are the sorts of things that companies typically put in those agreements, and any inventions that fall within those categories are ones that the company would claim that it owns. Usually they also include some provision that requires employees to give notice to the company when they've come up with something new, when they've come up with something that falls into that category. There may be, in some cases, I know for Sikorsky, we have obligations to some of our customers to tell them when we come up with a new invention. So we need to get that information from our employees first. I certainly don't know when the engineers out on the floor have come up with a new idea. Their obligation is to submit an invention disclosure on the process that I described earlier, to tell them about it. And then another piece that's very typical in those is that employees are obligated to maintain confidentiality of the information that the employer gives them access to. And it may not be just the employer's proprietary information, but in most cases it also includes information that other companies have entrusted to the employer. So again, I know that some of our suppliers, some of our customers provide their confidential information to Sikorsky, I expect all of the engineers in our company, all of the employees in our company, to protect that information as well as part of the employment agreement that they've signed with Sikorsky. So at this point, I got a couple of questions that we can run through here as a quiz, fairly quickly here, then I'll take some time to answer some questions. Maybe as they might come up as we're going through this. So for how long is a patent typically enforced? 10 years, 15, 20, or 25? 20 years. 20 years. Dead on. Very good. True or false? Getting a patent gives you the right to practice the invention. False. Does anybody think that's true? That's really important, and getting that mental concept right is something that I know I sometimes have a difficult time getting to some of the engineers in our company. It's always a little bit difficult to recognize that just because you got a patent on something, you can't necessarily guarantee that we're going to be able to do it. You still have to do patent work. How long do trade secrets last? 20 years, regardless of what measures you take. 20 years, but if you take and maintain confidentiality measures, indefinitely, regardless of measures, or indefinitely, but only if you take and maintain confidentiality measures. D, right. And on. True or false? You can enforce the United States patent in Canada.
No.
You can stop somebody from importing from Canada, but that's activity in the United States. You're absolutely right. Which of the following is not a right you obtain when you get a patent? The right to exclude others from making, the right to exclude others from importing, the right to exclude others from selling, and the right to exclude others from photographing. D, yeah, you can't stop somebody from photographing. If you happen to put your invention out there in the public, they can take a picture of it. People take pictures of our patented helicopters all the time, so you can't stop that. True or false? An invention can be protected at the same time by both a patent and trade secret protection. False. Absolutely, it's false. You may have a choice, right? So like I described in the case of the WD-40, back in 1958, they could choose, do I want to go trade secret? Do I want to go patent? But once they made the choice, that was it. You can't have the same protection at the same time. The quid pro quo, the exchange with the government for patents, that you get to tell them about your invention, that right there undoes any possibility of trade secret protection. Which of the following is not a term of most intellectual property agreements between an employer and an employee? A requirement to assign inventions to the employer, a requirement not to work for competitors, a requirement to maintain the confidentiality of information, and an acknowledgement that the employee owns any inventions.
B.
B, yes, that's right. It's in some fields, it may be possible. In some states, it may be possible for an employer to put some restrictions around which competitors or how soon you can work for competitors, but they would not be able to put in a blanket requirement that you cannot work for competitors. That's not possible in any state. What is the primary purpose of a trademark? Identify the source of goods, provide a marketing vehicle, ensure that others can copy the product, or protect functional aspects of an invention. Anybody? A, yes. It's identifying the source of goods. So I guess I should have spent more time on the trademark slide tonight. They may be a marketing vehicle, but you can market things without a trademark. You can market things without having trademark protection. A trademark does not ensure that somebody cannot copy the product, right? So I can, assuming there's no, well, coffee is a good example. I can go out and set my own coffee shop up. Starbucks may have a trademark associated with coffee, but I can set up my own coffee shop. I can make coffee that tastes the same as their coffee. And they don't protect functional aspects of an invention. That's something that a patent can do. How long after the first public use of an invention does a person have to file for a U.S. patent application? 12 months. Okay, so I heard a couple zeros, I heard a couple 12 months. C is the right answer. It's 12 months in the United States. Remember I said 1 year grace period in the United States. You make a public use, public disclosure of your invention, the clock starts ticking. You have 12 months to get on the final patent. Outside the United States, virtually every country, it is 0. But in the United States, 12 months. And last, you must only disclose one way of practicing the invention, and it does not necessarily have to be the best mode of practicing the invention. True or
False.
False. Absolutely. You gotta file, you gotta tell the patent office the best mode of doing it. All right. At this point, it's an opportunity to ask any questions. Yes.